Hi, this is Sue from Parkies and Me, My Journey with Parkinson's. Today I'm talking to Louise about enduring power of attorney. Welcome, Louise.
Thank you, Sue. Kia ora koutou. My name's Louise Taylor. I was a lawyer for a very long time before moving into mediation and commercial adjudication. Sue and I met as trustees on the Canterbury Westland Welfare Guardianship Trust. And Sue's asked me to talk about enduring powers of attorney. I thought maybe a good starting point would be to talk about the process for obtaining an enduring power of attorney, and then we can go from there. So the only people who are able to obtain an enduring power of attorney have to be over 18 and have cognitive capacity. Most people who get an enduring power of attorney are perfectly fine and have no knowledge of not being perfectly fine, but are wanting to protect themselves in the future.
Mm-hmm.
There are people, though, who are at early stages of a degenerative condition and are aware that there will come a time when their cognitive capacity slips below the line. It used to be the case in New Zealand. Anybody could just do it. It was a form on the internet. You downloaded it and did it yourself. Advantages of that, of course, are it's an awful lot cheaper,
Mm-hmm.
but it was open to abuse, and it was abused. There were arrangements within families and friends where people appointed as attorney were misusing that power significantly.
Mm.
So now it does require legal advice. It requires the person giving away that power, should they lose capacity, to be legally advised as to exactly what it is that they're giving away, what their options might look like, and what the implications are of that. A power of attorney, a formal written legal document, where that is, can be a mystery.
Mm.
My suggestion to you, if you are thinking about getting an enduring power of attorney, same as if you're getting a will, let people know where it is.
Yeah, that's good.
When it's needed. I've known a lot of families who've had somebody cremated, then found the will and found that they wanted to be buried. It's a bit late to undo that. The same with an enduring power of attorney. It might be let at least 5 people know where it is and leave it somewhere. Some people leave it with their lawyer, that's fine. It's also fine to have it at home, but just let somebody know where it is. In New Zealand, there's no central registry of enduring powers of attorney and who's got them. So it
Mm-hmm.
is entirely up to you to store it correctly.
As you're aware, Louise, I was up until recently a social worker working in hospital. And
Mhm.
when I asked whether they had an enduring power of attorney, some people would vaguely say, "Oh, I did something with the lawyer quite some time ago, but it
Yeah,
might have just been my will. I can't quite remember."
yeah,
The wife or whoever might be that person sort of goes, "Oh, yes, I remember us doing something with a lawyer, but very vague because they don't hold the
yeah.
documents."
No, and that's fair enough. And it might be 10 years ago
Mm.
when you're in a very different set of circumstances. So I can absolutely understand that. The thing is, for anybody to rely on it and say, well, okay, you have the right now to make decisions on behalf of this person,
Hmm.
you need to be able to see that document. You also need to make sure that it has been activated. So just because the attorney thinks the donor
Hmm.
has lost cognitive capacity means nothing. It has to be verified.
Hmm.
And it will say within the document itself, it will say how it's verified. Sometimes it's two GPs, sometimes it can be nurses, sometimes it's older people's mental health practitioners, sometimes it's psychiatrists. So whatever it says in there about verification is what you must.
Actually,
So if
Louise,
somebody comes,
their lawyer said the lawyer would activate the attorney for welfare.
you not
Yeah, my understanding, it has to be somebody with a medical background.
completely. It might be that the lawyer stores that because you get a certificate from the people to say person is
Hmm.
certified as having lost capacity. It may be that the lawyer who has the enduring powers of attorney is also wanting to keep a copy of that, but no, lawyers do not have the skills or ability to be deciding whether or not somebody has capacity.
Another situation that has arisen when I was working with people who had some level of brain injury, sometimes a lawyer would come in within about 2 weeks of that
Mm-hmm.
injury and wanting to have that person assessed as lacking capacity. Now, as most of us would know, it takes quite some time for a person to recover and to know what level of
Yes.
capacity they may retain. That was really concerning that family was getting lawyers in to do that so quick.
Especially with brain injuries or relaxing and remitting conditions or conditions that are just not stable. And the requirement to certify a person as having lost capacity is that the situation is stable. I agree, it's very worrying. If there was an urgent need to do something with that person's property, that person can go to court and get a property order to deal with that. There is no need to deal with it by power of attorney. That's a broad set of powers that are given. If they just need to do one specific thing, then it's not the right avenue to take.
All the medical professionals I've known that have had to sign off somebody as being lacking capacity, they don't do that in a hurry. They'll take their time to get to know the person, and it's a huge responsibility.
You're essentially taking a huge decision-making capacity from that person. The PPPR Act says that you can only take from people to the minimum extent required. One of the things that they're looking at is what capacity has this person got? Because sometimes it's the case that family are wanting to activate an enduring power of attorney because they don't agree with what this person is doing. However, that's not the criteria. The criteria is not eccentricity or even risk-taking.
I'd be written off quickly on those
absolutely.
conditions.
Those aren't the criteria. So I think there's a lot of trigger-happy behaviour around these things. When it is activated, the attorney doesn't have carte blanche to take over this person's life. They must consult the individual, family, and other people, and involve themselves to the minimum extent possible in this person's life. So I think it's one of those ones subject to a lot of misunderstanding.
The one for property, my understanding is that the welfare has to be activated in every case, whereas the enduring power of attorney for property can be set up either available immediately on signing or it could need to be activated. Is that correct?
Yeah, that's exactly right. Property one can either be a power of attorney, which is a standard sort of one. If you've got a child who's going overseas, they might give power of attorney to mum and dad to operate their bank account or do various things while they're away. So it's not enduring. It won't last beyond their capacity. But with property, you can set it up so that it starts now and endures later, or that it only starts to take effect when the loss of capacity has been authenticated. So yes, you do need to look carefully at what it actually says, which again is the reason why we need to know where the actual forms are, because there's a bit of detail in there.
Another situation, what would happen if a person had an illness and was in hospital and they have responsibilities in a business where they have to sign documents and they are in a leading role in that business, and there might be situations where they need their signature and somebody else's to activate things or do things. What happens with that business?
One is, if that is the situation, you need to have a power of attorney in place that says, if I am not available, this is the alternate. Any business set up that's a partnership or anything like that, you need to have a power of attorney for when you're not available. If that's not in place and you've got a bank account that requires two signatures, partner A and partner B, partner B is lying in a hospital bed with uncertain or lost capacity, then what happens to A? In essence, it's going to have to be the court that grants additional power. Going to be slow, it's going to be expensive, and it may be crippling to the business. If you've got a small business, a couple of guys who are running a small plumbing firm, there's only two of them, going to court and getting instructions is very difficult. So the advice of getting it sorted in your partnership agreement or in your company documents, what is going to happen in the event of somebody being unavailable is essential, because otherwise you are leaving decision-making to someone else. There will be situations the remaining parties are able to sort it out among themselves, but the purpose of law really is not to rely on goodwill. If goodwill exists and it does the job, great. But the purpose of law is to be there for protection when the goodwill's gone.
I've had situations where a person's come into hospital and the event is not so bad that they're going to lose capacity, but it's a good opportunity to sit down with them and find out whether they have a business that they jointly run, find out
Yeah.
whether they jointly own a home, those sorts of things. A lot of people think that enduring power of attorney and wills are only for old people.
And a lot of them think that they do more than they do or do less than they do. There's a lot of myths out there. But if you have involvement in a trust or a company or any business enterprise, you need to have a succession plan.
Mm.
And that includes succession when you're still alive but not available for a period of time. That is really important. And as you say, if somebody comes in to hospital and they got off a little bit lucky this time, might be the very perfect time to say to them, look, maybe next time not so much. So you need to think about where and how those instructions are going to be available.
It can be the sort of fright that pulls you up short. And when somebody says, do you realise if the company documents say that you both need to sign, that could be difficult if you weren't able to do that.
Yeah, exactly. So each person should nominate an alternate, or are they comfortable to say, well, it's two people most of the time, but in these circumstances, one is okay. I think my key message is take the control when you can get it. If it was the case that the person has lost capacity, then we're relying on guardianship and property management orders. Not the quickest processes. They can be expedited, but not the quickest processes. If you've got a partner and children relying on the income from that business, it could be catastrophic while you wait for that delay. But the legal costs, if you need to litigate it, could also be catastrophic.
Enduring power of attorney is, as an individual who has capacity, enduring power of attorney gives you the opportunity to nominate who you think would act as you would want them to act.
Yes.
If it goes to court and you lack capacity and you're non-verbal, for example, and somebody is going to appoint your wife because they think, oh, that's the logical person, we can't know what the relationship was like prior to the event. And so the
And
lawyer might be the last person they want to have.
yeah,
that.
exactly. I've had a lot of people come to me for enduring powers of attorney who've said, everybody will think that my brother's the right person because he speaks really well and he's well educated and eloquent. I know that his motivation will not be my best interests. He will be wanting to get his hands on property. Whether they're right in their assessment of their brother, I don't know. But I think they are right in that they are the right person to know who they want on their team.
Absolutely.
Some people do present better than they really are, and some people are not well motivated.
It always used to worry me when people said, oh, no, I don't think we need to bother. We can trust each other or whatever they say. I think casual arrangements can support them in the event that they need support, but it really has to be that legal document of enduring power of attorney, doesn't it?
Yes. From my perspective, I never see it when things go right. Nobody ever says, oh, I'll just pop into my lawyer and let them know that everything's going fine. I only see it when it goes wrong. I don't have a balanced view, but it seems to go wrong an awful lot. And when it does, it blows families to smithereens. In times where there's already a lot of stress because somebody's had an accident or got an illness or something is going on that's already very stressful. And now you've got a lot of voices, tensions that were already there now very much exposed. I strongly advise getting in there when you can.
You talked before about the complexity of families these days. You could be the third wife and he's saying, I want them to do things for me and I trust them. But the children from a previous marriage could say, no way she should be having that power over the estate.
And I've had it where we've got a wife unknown to the new partner that there is an existing wife. He's living with another family. There's children to both. There's stepchildren, and lives are very complex. There are sometimes players in there that you don't even know about. And there's also people who behave badly and are really disappointing in situations where greed and things like that take over and people can be surprising. So I think the short answer is to protect yourself when you can. The issue with powers of attorney is that you do have to pay for that legal service. And for a lot of people, that amount of money is huge, and
Yeah.
there is no legal aid to cover the cost. I do know if you ring around, it can help. It may also be the case that some lawyers, if you've done your conveyancing and whatever else through them, may offer you a very reasonable price. Always includes smaller suburban firms
Yeah.
who may have a lower cost structure. Or if you say, I need powers of attorney and will, how much will be the price for a package? I do appreciate cost is an issue, and that there is no way of meeting that cost there's no government sponsored way of meeting that cost, unfortunately. So that does rule out a whole lot of people thinking, oh, it's going to cost $500 to $700. To some people, that's nothing. For others, it's a month's food.
Absolutely. So we talked about the importance of enduring power of attorney. Is there some place that people can find a document or something that spells out the responsibilities for a welfare guardian, etc.?
Yes, if you go onto the Ministry of Justice website, it's got really good explanations there. So that would be my first choice. My second choice would be Citizens Advice Bureau.
Yeah.
Also have really good common sense explanations. And my third recommendation would be the Community Law website. Community Law is a manual which talks through all of these things. Between the three of those, you should be well covered. Just know that they really are not well designed for complex financial arrangements like trusts, company ownership, and business ownership and things that will require a more complex arrangement.
Okay. So what's your take-home message for enduring power of attorney?
If you separate, change your enduring power of attorney. You don't want the person you are now feuding with to have your power of attorney in the event of something happening to you. It's an active document. Every time you write a new one, it supersedes the prior one. You will need legal advice each time. It is an active document. So if you are listed as the attorney and it's 20 years later and things have now changed, when that person loses capacity, you're not required to take up that role. If you don't, they might have named an alternate, or that person will have to acquire guardianship. It is a statement of how things are on the day that it's written.
Yeah.
And be aware it's a living document. If you want to change things, the threshold at which it kicks in, you are entitled to, but it's going to have to get rewritten each time with legal costs attendant to it. The best prices I've found for people have come from their lawyer who's done their conveyancing, who throws it in for a better rate together with some other work, because it's linking that client to the firm. You
were talking about the complexity of relationships, and one thing I would encourage people to do if they find themselves in hospital is to check who they've got down as your contact, because I've had people come in and there's been a woman noted down as a contact, and they might have been 3 wives or 3 girlfriends ago.
Yes, exactly. There are some awkward conversations around ICU beds and things like that with, sort of, who are you? Yes, some people's lives are very chaotic and complicated. Try not to leave that to other people to sort out in the end.
Well, thank you, Louise. Did you want to say anything in closing?
No, it's been a pleasure, Sue. And any other time, just yell out and I will be there.
That's awesome. Thank you, Louise. This has been Sue for Parkies and Me, my journey with Parkinson's. Thank you for joining me, Louise, and thank you for following me. Kia kaha, be brave, be strong, be you.